Welcome to Estate Planning Beyond the Binder.
Welcome back to Estate Planning Beyond the Binder with Brian Chu, managing partner at OC Wills and Trust Attorneys and a leading estate planning attorney serving Orange County families for over 25 years. I'm Leanne Lyon, and today we are talking about the estate planning legal checklist every parent needs to know about before their child heads to college. Brian, let's start with a real scenario. What is an emergency situation you've seen that caught parents completely off guard?
I think the most common is, as somebody who has a daughter who's about to go off to college next year, the issue is, our children, they're far away and God forbid they end up, getting a car accident or something like that, end up in a hospital somewhere and they're unconscious. And because they're adults, we have even, obviously once we even become aware of the issue, the hospital and doctor may or may not be able to talk to us because of HIPAA laws. All adults have medical privacy, and doctors and other health institutions aren't allowed to disclose medical information when you're an adult to anybody without written permission. And unfortunately, if your child were to, end up in a hospital unconscious, they're not able to give that permission. And, the days of people able to call a hospital and, get information about somebody, those are long gone. And so, that's obviously a nightmare situation for somebody where they can't even get information because technically the hospital is not allowed to give that information to anyone.
Why does everything change legally once a student turns 18, even though they're still financially dependent?
Unfortunately, it has nothing to do with finances or who's paying the insurance. Even on the, they may, even on the medical insurance, you may be paying for that insurance, but you have no right to their medical information. All adults, anybody over 18, has the right to medical privacy from everybody else. And technically hospitals and other health institutions are not allowed to release information about your health to anybody else without written permission.
Well, some parents worry about these documents that they could take away their child's independence. Is that really the case?
No, these documents can, when I quite commonly, when I have clients that, they're, kids are going away to college, they'll have the kids sign a power of attorney and a healthcare directive. The healthcare directive being the document that authorizes the parents, in this case, the right to get medical information about them. But quite often, these directives are not don't go into effect in terms of being able to make decisions for the parents until that child's actually incapacitated. Okay, so as long as the kids are able to make decisions, they'll make decisions. The parents, they just have the right to get access information, but they can't make decisions unless the child's actually incapacitated.
Now, I think you just mentioned two documents. Why isn't a HIPAA authorization alone enough in a medical emergency?
So there's two documents typically involved. There's, like I said, you mentioned HIPAA authorization and a healthcare directive. So the HIPAA authorization is what allows the hospital to discuss your medical records with somebody else, a person that's been authorized on the HIPAA authorization list. The healthcare directive, which is what we call it here, might be slightly different. It might be a healthcare power of attorney in other states. That's the document that dictates what decisions you want to be made in terms of end of life type decisions and things like that. And then authorizes someone to make those decisions. So they are two very different things. One is about getting access to information. One is about actually being able to make decisions when I cannot. If it's the student who can make decisions for them if they cannot.
So beyond medical charts, what happens when a student is incapacitated and the parents are locked out of the university portal, banking apps, or two-factor authentication devices?
It's hard. You do have to grant that permission. And an example, power of attorney, which is more financial and legal affairs, dealing with the school, because obviously that's not a medical issue necessarily. But again, if your child's incapacitated, the power of attorney example is what would give you access, the ability to access those documents or access those accounts and or make financial and legal decisions. Obviously, if you don't have those documents, unfortunately, the only recourse for if I have to take over somebody's estate because they're incapacitated is to go to court in what's called a conservatorship. Uh, in this case of, and there's two types of conservatorships: conservatorship of the person, which is if you didn't have documents and you need to make medical decisions for somebody, and or conservatorship of the estate if you have to make financial and legal decisions for somebody. And that's obviously that's a court proceeding. That's probably going to require a hire attorney, and that typically doesn't happen right away. Let alone, obviously it makes it even worse. Obviously, if your child's far away, now you're having to hire an attorney in some other state, and they're going to court on your behalf at that point.
So, how do you explain the purpose of these documents to students who feel uncomfortable signing them?
For the most part, really, when my clients, students have come in, their children come in to sign these documents, they're usually pretty receptive to it. They realize, they're effectively on their own when they, go to, they go to another state, especially, or leave home. They know they're on their own. And again, these documents, if they're based on incapacity, doesn't give the parents any rights to make decisions for them as long as the children can make decisions. Okay.
Got it.
And obviously, the children are only going to sign these documents if they trust their parents. And so as long as they trust the parents, but at the end of the day, we all have to trust somebody because we just never know when something's going to happen. That's why we do estate planning. That's why we do these documents. And in this case, it's not so much about money and wealth transfer and things like that, like traditional estate planning is. It's just making sure somebody can make decisions when I can't. Yeah, I mean, it's just about making sure that somebody can make decisions when I can't. And because if I can't make decisions, I want to make sure somebody can, and it's somebody I trust. I get to choose. Okay, so whether it's your parents or it could be siblings, cousins, whatever it is, you want to make sure, in this case for a student, that somebody has the authority to make decisions for you without having to go to court.
Out of curiosity, have you had students make that choice to choose somebody other than their parents?
Not typically. I mean, I don't recall. I mean, a lot of times they'll have siblings and maybe other people potentially as backups, but typically, since usually the people coming to me are it's the parents. I've suggested they get this done for their children. They're the ones who are suggesting to the children that they create these documents.
Got it. Well, many parents believe that as the next of kin, they'll automatically be able to step in and act for their college-age child. Why is this an absolute myth?
Well, I don't know. It's absolute. I mean, the reality is, if you don't have documents, you're leaving it up to the institution to make a judgment call whether to allow the parents to get information. Now, a lot of times we see in person, the parents, they'll typically talk to the parents a lot more in person. But obviously, over the phone, again, the days of calling the hospital and going over the phone, I mean, they don't know who you are,
Right.
and you're typically not carrying around papers saying I'm somebody's parent. And so, by having these documents that are, signed by the student and notarized, that at least gives the hospital, the right to say, hey, we had a signed document that said this person has the right to get information about you. But there are circumstances where they will talk to the parents, but again, that's you're trusting or counting on that institution to break their own protocol. And I just don't want to count on that. I mean, it does happen, especially in person. I've talked to ER doctors and things like that, and they will break that protocol. Obviously, sometimes it's a little more urgent and stuff like that, and so they're a little less concerned about being sued. But
Mhm.
certainly, just somebody calling the hospital and saying I want information about this person or I want to discuss this person's medical information, you are just for them to do that is really violating the protocol, and I don't as a parent I don't want to count on them deciding to violate the protocol.
Right.
I
Well,
want things to go smoothly as possible.
that makes a lot of sense. When is the best time for families to put these documents in place?
I mean, I would say, as soon as my child, as soon as my daughter, example, is be turning 18 here soon. As soon as she turns 18, as soon as they're an adult, because it's not just about going away. I mean, it could be they're traveling, or it could be any number of circumstances. Even if it is local, if they are local, I still don't want to have any bureaucracy involved with getting them to be able to discuss information with me. Okay, I'd rather have a document in place. And again, as soon so if they're minors, there's no issue. Okay, if they're minors, you have access to their information as the parent. But as soon as they turn 18, that's when I tell my clients that that's when you want to start asking your child if they're okay with this.
So, if parents have just one takeaway from this message, what should it be?
Just be proactive. I mean, have a discussion with your children, when they turn 18, and discuss the importance. Obviously, presuming nothing's going to happen, okay, but you never know, and that's what this is about. It's you never know what could happen, and it'd be better to have these, these 3 or 4 documents in place just in case. Hopefully, it won't be needed, but at least it's there if it's needed, and hopefully gives the parents some peace of mind, knowing that if something did happen, they have the right to do things.
Well, we know your estate plan is only as strong as the people you trust to carry it out. If you're not sure who to name, or you just want to make sure your choices are still a good fit, Brian and his team can walk you through your options and make sure you make the right call. Visit www.ocwillsandtrusts.com to learn more or schedule a time to talk. Also, be sure to like, subscribe, and leave a review if you enjoyed today's episode. Thank you, Brian.
All right. Thank you, Leanne. Thanks for having me on.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.